the AIC newsletter that goes out has a link. There's the Bliss McKnight icon in there. If you click on it, it talks about newly elected officials. And somebody alluded to, we have a website called Practical HR Resources. And on that website, there are two really short videos, like a 4-minute video and a 5-minute video. And so I put this in the back of the room. This tells you how to get to that website, and you click on this red button that says newly elected officials alert, I think is what it says. You click on that red button, it takes you to a page that looks a lot like this, and it says, watch these videos, okay? Because I think the question that somebody was asking was proving something. So for the most part, you can't just fire people, right? But newly elected officials can fire for 2 different exemptions, all right? And they got to be policy-making decisions. So you might have to, and the courts would say that you have to prove that they're policy-making decisions, or this is pretty much what I think most of the folks would fall into. It's confidential or trusted positions. So those would be like your first deputies, all right? You would have to prove that they are confidential or trusted positions. And those videos really quickly walk you through like understanding what those exemptions are, all right? So AIC newsletter has a link, and I put these things in the back. And I also put this is an alert. It says, you won the election, now what? And it talks specifically about who you can fire after you're newly elected, all right? So if we want to go to noon, we can go to noon, or we could be done in like a second. If you have HR questions or issues, you should be going to an attorney or an HR expert. I'm done, all right? If you're not doing that, you're probably setting yourself up for some problems. But I understand that you need to be kind of muddling your way through and trying to answer questions yourselves. So I'll do this longer version for those of you who didn't like the answer I just gave. All right, so I am going to talk about sex first. Somebody in the front, she's ready to go. Yeah. Oh, darn it. So, you would think that we've been dealing with issues of sexual harassment and prevention and training for a lot of years now. So why are we still having claims and lawsuits? Let's talk about that. Actually, we are in the Me Too era, all right? The hashtag Me Too, where the idea of folks being harassed is taking center stage. So how did that affect employers? Well, in 2018, there was a 12% increase in workplace sexual harassment complaints compared to 2017. There were 50% more sexual harassment lawsuits filed in 2018 than in 2017, all right? And this is the EEOC's number, about $70 million collected for victims through litigation and administration enforcement. So employers are in the hot seat. You have more people coming at you because it's just, there's a heightened awareness to sexual harassment and what is sexual harassment. Some states have addressed this by having specific training requirements. Indiana is not one of them. So how many of you do sexual harassment training for your employees? Raise the hands really high. Wow. Jeez, you guys got to get active. I told Mark, I said, I'm really sorry, Mark, because I'm probably going to drum up business for you because if you don't do sexual harassment training, you should. And probably when I say you should, I don't mean you should. I mean you should get somebody to do your training for you, and you should probably get someone like him, all right? Why? Why should you do training? Training's recommended by state and federal agencies. The EEOC has been pushing out a whole bunch of information about why you need to get training, and then they're even getting real specific. They're issuing guidance saying things like sexual harassment prevention training should involve real conversations. So I see opportunities, well, strengths, weaknesses, opportunities, and threats. I would say that there's a threat to bad training. If you pop a video in for 15 minutes and you have your employees watch it and then they sign a form, I really think that there's an opportunity for that training to be found lacking and wanting, because there's specific things that you need to include in your sexual harassment training, and they're not going to be included in a generic video, all right? It's going to be really good to educate people about sexual harassment and discrimination, but there are other things that you're required to do as an employer to get this thing called safe harbor, all right? What is safe harbor? I have another handout. I'll put this in the back. The courts have recognized what we call a safe harbor for an employer who acts reasonably to try to prevent sexual harassment from occurring, okay? So right away, when you hear words like reasonably, you should be thinking those are lawyer words, which means they're going to be grades. What's reasonable? Nobody's reasonable. So, I mean, we're not going to have a common definition, and we'll talk about that a little bit too. So if an incident occurs in your workplace, this safe harbor can protect you if you have done 3 things. And I'm going to tell you what those 3 things are, and I'm going to leave you with this handout too, okay? I didn't put it on the slide. Why do that? So, your 3 things. Have a written anti-harassment policy. That policy needs to make clear what the complaint procedure is, and that policy needs to be distributed to all employees. Okay, that's 1. 2, conduct anti-sexual harassment training for your employees. The EEOC says every 1 or 2 years. So if you've done it in 1999, it's time to do it again. The EEOC also recommends that the training be done live, in person. One of the things they said is they want these conversations, they want dialogue. They don't want it to just be you pop a video in and then you're done. And the 3rd thing is, as you all talked about, conduct prompt investigations of all complaints brought to your attention, and if a violation is found, take appropriate remedial action against the offender. If you do those 3 things, the court will recognize you took action to prevent harassment from occurring, and you're in a safe harbor. All right? Those 3 things, real simple. Not that simple, though. And there were parts within parts, right? So I'm going to leave this sexual harassment safe harbor handout. I'll put it in the back for everybody. So there weren't a lot of hands that went up when you were talking about, when I asked the question, do you do sexual harassment training? So get on the stick. Another thing is, when you're doing sexual harassment training or discrimination training, you should do different training for your managers and supervisors. They can go in and be involved in the training with all the employees, but their responsibilities are different, and they need to be aware of those responsibilities. We've had situations where claims have developed because an employee went up to a supervisor or a manager and made them aware of a situation that was occurring, and the supervisor or manager, went home and told their wife and said, "You would not believe what's happening at work," but they didn't tell anybody else, so no action took place. The thing is, when that employee told a supervisor or a manager about something taking place, that was notice. That was notice on the employer. So if a supervisor and a manager doesn't understand what their responsibility is to do once they've been notified, that can get you as the employer, the county as an employer, in trouble. Okay? So what I wanted to do is kind of show you what a sexual harassment training ought to be like, all right? Let's say that we're going to include a video and it's going to have those horribly embarrassing vignettes, which we use, but they're good because they're visible, they demonstrate what sexual harassment is, and they're also consistent, right? So the same videos are shown to every employee, and everybody could say, "Oh yeah, I did see, the touching, the hugging, I saw those things that we shouldn't do." So that's good. But there's other things that need to be part of your sexual harassment training, right? It's got to be live in person. So I'm coming here and I'm doing a sexual harassment training for Happy County, right? And I'm going to say, we're going to cover today what is sexual harassment. So you all understand what the legal definition of sexual harassment is. Why it's important for us to have a sexual harassment training in our workplace. Why we want to prevent that. What our county's policy is. That's a biggie, all right? It's kind of numero uno why you're doing this, right? That's why you're doing it live. That's the part where if you throw a video in, you need to cover your county's policy on harassment. And then we're going to talk about your responsibilities. And if I'm talking to employees here, I'm going to tell the employees what their responsibilities are. If I'm talking to supervisors and managers, I'm going to be talking to them about what their responsibilities are. So you tailor this for the audience that you're talking to. I'm going to tell them sexual harassment training is not required under federal law, but many states have enacted legislation requiring training, but we're doing it because it's good practice. It's a good business practice. We all work together. We all want to get along. We're not at a bar. We're not sitting around our kitchen table. We're at work. We come here to get a job done so we can all be respectful. We can all be we can leave those things that are not appropriate in the workplace. We can just leave them outside the door. They don't need to come in, all right? So why are we here? To help you understand what is inappropriate workplace conduct, and it may equate to unlawful workplace harassment. One of the common misconceptions that employees have is that all sexual harassment is going to be illegal. And it's going to result in someone getting fired. It's going to result in a lawsuit. When what happens in sexual harassment, where's Melissa? Is she hiding? Pardon me? Oh. What would happen when sexual harassment, when you find out about it as an employer, you would do an investigation and you could take action. You could say, please stop harassing that man right there. Don't do that anymore. You can take simple actions. It might be that we have to put her at a different workplace. We have to separate them. We might have to counsel her. We might have to provide some training to her a little bit more in depth. Oh, you didn't realize that type of touching was making him uncomfortable. Okay. So a lot of employees don't come forward until things get to a really bad place because they think, I don't want to get this person in trouble. I want to get them fired. I don't want there to be a lawsuit. When really, they could come forward and say, this behavior is just not comfortable for me. So we have to let them know that that's okay for them to make you as an employer aware. We also want to communicate to employees that the county has a policy that we don't tolerate harassment. We want to tell you the procedure for addressing harassment complaints, and we want to demonstrate that our county is committed to having a respectful and harassment-free workplace. So what is sexual harassment? Everybody thinks they know. Well, we're going to walk them through the EEOC definition. It's unwelcome sexual advances, requests for sexual favors. We're a technology-driven society now, so there's other things. We can have, in addition to verbal, we can have written, electronic, email, cell phone texting, all that conduct that can affect an individual's employment and interfere with their work performance. It can create an intimidating, hostile, or offensive work environment. So what's unwelcome? Again, so anytime that we have a definition, then we have to define the words within the definition, right? So what's unwelcome? Well, we have some court cases that help us understand what unwelcome is, and it's conduct that must be unwelcome in the sense that the employee did not incite it, in the sense that the employee regarded the conduct as undesirable or offensive. Okay, undesirable or offensive. Here's the problem, though. What's unwelcome? These two gold dots are the same size, right? Trust me, they are. So it's an optical illusion. You think that they're different sizes. They're not. This is the problem with sexual harassment because the harassing is in the eye of the beholder. To me, it's small. To you, it's large, or vice versa. Okay? So we have to have our employees understand this concept, that they can come forward and talk about something that they think is undesirable, unwanted, and it might be at a different threshold or level than what somebody else might feel. What is sexual harassment? Two legal definitions here. Quid pro quo. It's what mainly people think about when they think about sexual harassment. It's this for that. You want the job, you go out with me. And a hostile work environment. So quid pro quo is when there's a tangible employment action against the victim. It usually involves a monetary loss or change in job. You're fired, you're demoted, you didn't get promoted, you didn't get the good shift, etc. I just did that. Hostile work environment. This is one that we stumble into. I think workplaces stumble into this, more or less. It's where speech or conduct is severe enough to create an abusive or hostile work environment. It's a guy who's always leering and intentionally brushing up against somebody. It can also be suggestive items, emails, texts, things displayed in the workplace that interferes with job performance and creates an abusive or hostile work environment. This is the no Playgirl calendars in your cubicle, no Playboy calendars in your cubicle. These are, don't have a screensaver that's inappropriate. It's not cool or funny to forward inappropriate emails to people, or have so texting and instant messaging people with explicit jokes. It could also be in a workplace that 5 or 6 people are all comfortable talking about various things that went on over the weekend, but somebody is not comfortable with that. So this goes back to that, the harassment's in the eye of the beholder. Somebody is offended by that type of behavior. And I think actually Melissa was saying that that was the situation that they had to investigate in their workplace, where one person saw it one way, one person saw it another. It was actually 2 gentlemen. It was an interesting story. Why'd she leave? One guy was commenting on another woman's appearance. She didn't file a harassment claim. The other guy did. And he said, "You're a jerk." That's really offensive. That really makes me uncomfortable to be in a workplace where you're constantly talking that way. So that would be, the EEOC, the standard is a reasonable person standard, okay? In determining whether harassment is sufficiently severe or pervasive to create a hostile work environment, the harasser's conduct should be evaluated from the objective standpoint of a reasonable person. I'm reasonable. But my wife wouldn't tell you that. I mean, I'm wearing black pants and a navy sweater, all right? I goofed up. I'm watching Downton Abbey. I need a valet, all right? I don't know how I left looking like this. My wife would be like, "You're not a reasonable person, Tim. You're an idiot." But Title VII doesn't serve as a vehicle for vindicating the petty slights suffered by the hypersensitive. So we know that we're going to have a spectrum. And at one side, it's going to be really bad stuff, and then it's going to move, and it's going to get grayer and grayer and whiter, and right? So we're going to be on that scale. The county's challenge is to educate employees to understand that there's this scale, and there's a spectrum, but the county has policies that need to be followed. So the reasonable person standard, right? 2 people can look at the same thing. One person says, "There's 4 bars," and one person says, "There's 3 bars." It's a nice optical illusion. I like that. But the reasonable person standard can be very confusing because that's a legal term, and you don't want to get into that. You don't want to be in court having somebody determine whether it was reasonable or not. You want to have taken action at your workplace. What are some elements that you would find in a hostile work environment? Pornography, vulgar language, sexual touching, sexual propositions, degrading comments, embarrassing questions, sexual jokes. Just when we're training employees, one of the things we'd be saying is, this stuff, just don't bring it into the workplace. It doesn't have a home here. It doesn't need to be in our county. It can be when we're joking around at the bar or doing something else. Who can commit sexual harassment? This sometimes is an eye-opening concept for employees. Employees at all levels, customers or vendors, So if you have a customer that constantly comes into your office and they always do that creepy thing, that employee can say, someone needs to take action about that. Right, you know what I'm saying. And members of the same sex. So employees might be confused about that, like that situation I explained about, two male employees with a female employee. The male was the one who said, I'm offended by this. Who are victims? Everybody. Individual or individuals targeted by statements or actions. Bystander or witnesses not directly targeted. One of the things that the EEOC is really pushing is training for bystanders. And the idea is if you really want to stop harassment in your workplace, oftentimes the person who's feeling victimized is quiet. Because they're feeling victimized. So we have to empower third parties, the bystanders, to be able to say, hey, can you stop that? Cool it. I know maybe you don't see that you're making them uncomfortable, but that's just a real bad move. Stop that. So bystander training is like, I'm seeing a lot of products coming into the market by HR companies, videos and that type of things. I think it's got a really good place, and I think that's probably what we want to do if we really want to squelch sexual harassment in the workplace. We got to make everybody feel that they have a responsibility and that they're on the team. Because the idea that if you're being harassed, it's up to you to take action can be a really daunting task. And at the end of the day, we don't want lawsuits. We want the behavior to be gone, right? Because once it gets to the lawsuit stage, you're in trouble. Third-party harassment. I think I've talked about this. It's behavior not found offensive by some people, but it creates an offensive environment for others. People are all talking about their sex lives and it makes somebody in the group feel uncomfortable. What does that person do? They don't say anything. They're just quiet. It's hard to come forward. So it'd be really cool if one of those bystanders would say, hey, you know what? I don't really think this is what we should be talking about at work. So why is it important to prevent sexual harassment in the workplace? Because it harms us. It ruins productivity. People are offended. If you're uncomfortable, you're not working to your maximum. Your morale is low and it just slows everything down. Also, employees should be treated with respect and dignity. Their coworkers, we're just here to do our job. Let's come in, let's do our job, get along, and move on. So engaging, condoning, and not reporting sexual harassment is in conflict with our county's values. Yes, we want to remain in compliance with Title VII of the Civil Rights Act, which prohibits sex discrimination, and we want to remain in compliance with any other civil rights laws. But our first thing would be to have our workplace enjoyable. Now, the key component of your sexual harassment training, now is when you would point to your county's sexual harassment policy. And you would say, our policy says A, B, and C. These are the folks you report harassment to. Your policy is typically going to have a couple of safety valves. For instance, if she's your supervisor and you're being harassed by her, you can't go to her, but so you need your policy to say you can go to that person or that person or that person or that person, right? You need to have that safety valve in your policy. And the employees need to understand what that safety valve is. Also in the back of our heads, because you're not employees, you guys are county officials, we know that this is also putting us into that safe harbor because we're having a policy, we're distributing it to our employees, we're educating them on it, and we've got a system for how we're going to address sexual harassment. So one of the concepts we want to get across to our employees is that responsibility for keeping sexual harassment out of the workplace is everyone's responsibility. It's not just the victims, it's not just the harasser, it's everybody. We can all work together. So, as an employee, what's our responsibilities? We need to know and comply with our policy and procedure. We need to report incidents that you experience directly or witness. We want to cooperate with investigations, and we want to support people who are victims of harassment in the workplace. That could be as simple as saying, yeah, I'm really sorry that that person did that. I'm going to go talk to our supervisor about that. So supervisors and managers have additional responsibilities. One thing is set an example. I don't know if every supervisor or manager is really setting an example. If they're coming in and they're telling the dirty jokes and the bad stories over the weekend and the inappropriate comments, they're not setting your example, right? And the employees are going to follow their lead and say, this is a joke. So your supervisors have to take the mantle up of setting an example. They need to understand the anti-harassment policy and follow it. For example, supervisors and managers need to know that if someone walks up to them and says, hey, I really don't want to get Fred in trouble, but he's done A, B, C, and D. But I don't want to make a report. I'm just telling you. What is that? It's a report. Yeah, it's a report. It's official. There is no off-the-record harassment bunny that makes it all go away and sprinkles, fairy dust over it. If you're notified, you're notified. It doesn't matter how it came to you. If it came to a supervisor or a manager or somebody else, that's notification. So as supervisor and managers, they have responsibility to know what that next step is. What do they do with that notification? And we want supervisors and managers to know that they can notify anybody if someone makes them uncomfortable or if someone's behaving in a way that's inappropriate. Supervisor and managers' number one responsibility: take all complaints seriously. You can't brush it off and say, that person's always complaining, that person's never happy, that person doesn't like so-and-so. Take the complaint seriously. Take it on its face as a sexual harassment notification. So when you get a complaint, what do? You can go to the harasser and say, hey, did you know that this was taking place? Did you understand that that's how this person felt? Stop. I mean, you can cool this in its tracks. You can just cut it off right then, perhaps. Maybe, maybe not. And use your employer's complaint procedure. If whatever documentation needs to be done, if it needs to go into an additional investigation, if you walk up to said individual and say, did you do A, B, and C? It's surprising. We get these really funky claims in the office that this guy was writing incredible things to a fellow employee who was a female. And when they went to him and said, holy cow, this is so egregious. Surely you're not doing this. He was like, yeah. Like, oh, well, stop. Don't do this anymore. They said it a little bit more strenuously. Employees should report harassment to the employer before it becomes severe and pervasive. That'd be great. And our employees need to understand that isolated incidents of harassment are generally not violating federal law, but a pattern of that type of behavior can be unlawful. All right. So we'd like to stop it before it moves to that stage. Also, employees need to know that they can come forward with allegations of some type of harassment, and there will not be retaliation against them. There won't be retaliation against me for reporting it as a victim, me reporting it as I'm a third party, I witnessed it, and I just want to bring that forward, okay? And you can't be retaliated against for participating in an investigation. Let's say that you didn't come forward, you're in the group of people, somebody says, those 3 people all heard him do this these 15 times, but they didn't come forward. Now they get involved in the investigation. They can't be harassed. They can't be retaliated against, okay? To the extent possible, this is a big caveat, to the extent possible, your investigation should be as confidential as possible. Obviously, everybody's going to know who the harasser and the victim are, probably. But to the extent possible, you don't talk about this. As supervisors, as managers, you don't say, yeah, this is what he did. No, you stop. Okay, now we're going to test our knowledge. I have a question. Oh.
Okay, let's say that you do have some sexual harassment going on, and it is witnessed by 2 other people. And in your investigation, can you discuss with those people, if this continues, you guys need to make sure you report it to me? Like I had an incident where there were 3 people. There was one lady that was being harassed. An outside male was doing the harassment, but there were 2 other coworkers that witnessed the harassment. And the 2 coworkers, the ones that told me. And when I called the lady in, I made it clear to her that if it continued, she was to report that immediately.
Oh, yes.
And because she was intimidated, but I wanted to.
Yeah,
make sure
it's
it was put on
intimidating.
Me, as her supervisor, that I could not let that go on.
It sounds like you handled it
So
perfectly.
Can you bring that up with the other coworkers?
Heck
that did
yeah.
report it?
And it should be in your, to the extent possible, it could be in your policy too, that you're encouraging witnesses and bystanders to report harassment when they see it. Yes.
This presentation seemed, I assume by purpose, to be specific to sexual harassment.
Mm-hmm.
But what about harassment that is specific to one gender versus another?
Yeah. So here's the deal. We would recommend that you do harassment training on all types of harassment, right? You could do a big thing on all types of harassment. The thing is, this sexual harassment probably deserves a carve out in and of itself because of the numbers that I indicated in the beginning. This is a hotter, and I don't mean like it's new and now. I mean, it incites fear. I think it's more pervasive. So if you would like a harassment training that includes all types of harassment and discrimination, go for it. I do think that there are good legal reasons why you would want to carve out some specific training for sexual harassment. And I think a lot of it would be the legal reasons, the safe harbor stuff, the things where you want to make sure that you can check the box, I've done those things. If those things are included in your other harassment training, great. But I think there's some stuff that needs to be communicated in sexual harassment that's really specific to sexual harassment. Mark, you do harassment training, right?
Yeah, we conduct our trainings across the board. It's all covers Title VII, and of course we get into the Americans with Disabilities Act, Age Discrimination and Employment Act, and all the federal statutes. We talk about those
Yeah.
as far as the discrimination in the workplace. So yes,
Do you have people that ask you for just sexual harassment?
not normally.
Okay.
Thank you.
I would just make sure you cover this in a clear way, so that from the employer standpoint, you've got those safe harbor protections. Great question. True or false? Asking a coworker for one date is sexual harassment. False. Asking for one date alone, usually not a problem. However, problems arise with repeatedly rejected requests for dates. So sad. It's okay to harass persons who are or perceived as being homosexual because they're not in a protected class. False. These jokes will be based on sex and considered a form of discrimination and harassment, which reminds me, I made a note here. It's hard to stay up to date on things that are happening. So for instance, if you have, Melissa mentioned HR 360, I'm not familiar with that. Folks in the Bliss McKnight program have this thing called Practical HR Resources, and you get emails sent out to you. And they kind of keep you up to date on the changing litigation landscape. We are in the 7th Circuit here, Illinois, Indiana, and Wisconsin, and we have a distinction. The 7th Circuit found that sexual orientation is sex discrimination under Title VII. So, the other protected classes, sex, race, color, religion, you can add to that if you'd like to, sexual orientation as well. In April of 2017, the Hively versus Ivy Tech case was heard by the 7th Circuit, or decided by the 7th Circuit. It's the first federal appellate court to find sexual orientation is included in Title VII of the Civil Rights Act of 1964. So if you thought you could discriminate based on sexual orientation, you can't, at least in Illinois, Indiana, and Wisconsin. So stop it. What's interesting is what they found is, well, it's sex discrimination. It's just straight up sex discrimination. So it really wasn't, I don't know, I didn't think it was that earth-shaking, but I guess it was. What do I know? Jokes cannot be harassment as long as they are funny. That's the rule in my house, but false. If jokes denigrate a protected class, they can be considered harassment if sufficiently severe and pervasive to alter an employee's terms of employment. Listening to Bob and Tom on the radio during the day loudly enough that it can be clearly heard by others in the area can be harassment. True. Shoot. Because of the nature of the radio program, replete with sexual innuendo and outright sexual content, broadcasting it loudly enough for others to hear in the workplace is inappropriate. That's the type of thing I think that people stumble into, right? A single incident is not considered sexual harassment. I heard a couple. I think that one's trickier. It's false. Although courts generally consider frequency and pervasiveness of actions, single incidents can be unlawful. Although typically we tell people a single incident is probably not going to be unlawful. But Title VII prohibits discrimination and harassment on the basis of sex only. False. Title VII prohibits discrimination based on race, color, national origin, and religion, as well as on the basis of sex. So what Mark's saying is he provides training on all those. He's going to cover everything. Male employees can sue for sexual harassment even if the harasser is also a man. True. The U.S. Supreme Court recognizes same-sex harassment. Employees usually are not responsible for harassment based on things they say because they have a constitutional right to free speech. False. The U.S. Constitution does not protect harassing speech by private citizens against other private citizens. Totally different, though, from what they put on Facebook when they talk badly about you as an elected official. Right. So in summary, sexual harassment is unwelcome sexual advances, requests for sexual favors, and other verbal, written, electronic, or physical conduct of a sexual nature that affects an individual's employment, unreasonably interferes with his or her work performance, or creates an intimidating, hostile, or offensive work environment. There are two forms of sexual harassment, quid pro quo and hostile work environment. It's important to prevent sexual harassment in our workplace because it harms us all. It conflicts with our county's values, and employees should be treated with respect and dignity. Sexual harassment is illegal, and your responsibilities are to know and comply with our county's policy and procedure, report incidents that you experience directly or witness, and cooperate with investigations and support victims. So that's a sexual harassment program that you ought to be giving to your employees. If you want to give them harassment overall, you ought to be doing it. I didn't see a lot of hands go up. I'm a little bit surprised. I thought you guys were a little bit more active. But that's what you need to do. Remember the safe harbor concept. If you've got a policy, that's great. That's great. But now you need to be doing the training on the policy as well. Any other questions? All right, that was the sex portion.